All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in CR21 0389, State versus Santillanes. Counsel, we have read the briefs, the supplemental briefs. We've discussed this matter in conference this morning. Each side has 20 minutes to present their case. Ms. Klepper, you may go.
May it please the Court, my name is Faith Klepper. I represent the state of Arizona, and I'd like to reserve 5 minutes for rebuttal. The state appeals an expungement order in which the trial court abused its discretion by expunging a marijuana offense that involved more than 60 times the weight limit allowable under the statute and approximately 13 times the weight limit for a cannabis offense in ARS 36-2862. The state has the right to direct appeal pursuant to ARS section 13-4032 subsection 4 because this order affects a substantial right of the state in two ways. First of all, it denies the state the right to uphold a validly obtained conviction, and secondly, because it denies the state the right to present the explicit right in the statute to present evidence of the defendant's ineligibility. With respect to the right to uphold a valid conviction, we can see if we look at 4032 as a whole that the statute allows the state to directly appeal cases in which a trial court takes subsequent action to a guilty verdict that eliminates the conviction. In particular, if we look at subsection 2 and 7, which you have is, first of all, in 2, the statute explicitly allows the state to appeal an order for a motion, granting a motion for a new trial, and in subsection 7, a trial court order entering a judgment of acquittal after a guilty determination.
But this is neither an acquittal or a motion for a new trial. And this is recognizing the validity of the original conviction, but simply eliminating the ability for other people to see that he or she was convicted of an offense.
It's analogous, however, Your Honor, in the fact that in both of those cases, as in this case, it's a trial court action subsequent to a guilty determination. So in that case, the state does have the right to seek review of a subsequent trial court action. And that's what happened in this case. We have a validly obtained conviction through the guilty plea, and then later on, a trial court action that eliminates that conviction. It's analogous to both of those other subsections. Additionally, the expungement statute gives the state the explicit right to present evidence of ineligibility, and that is something when this court has acknowledged, particularly in Corno, that when the state is given the ability to do something in the ordinary course of procedure, in that case it was the right to withdraw from a plea under Rule 17.4. This court acknowledged that because they have that, the state has the ability to do that, that then a substantial right is affected. And in particular, with regard to subsection B3 of the statute.
Assuming we disagree with you, we still have jurisdiction on a special action, don't we?
Yes, Your Honor. Both State versus Bayardi and State versus Bernini, which the state cited in its briefing, this court has indicated that it has the discretion to treat a an appeal as a petition for special action where there is no it does not find direct appeal jurisdiction, or the jurisdiction is not clear. And in this case, if the court does not find that there is the right to direct appeal for the state, then it should treat this as a petition for special action, because obviously as a recently enacted law, this is an issue of first impression. It's one that is of statewide importance, and the fact that there may not be a right to direct appeal by the state, it's something that it has the possibility to evade review. However, I would note that subsection B4 does set out that the trial court must set forth findings of fact and conclusions of law whether it grants or denies a petition. And if the drafters of the statute did not anticipate that the state would be permitted to seek review of the granting of an expungement in this court, it would not have put that in there. It could have simply drafted in saying, if you deny this petition, then the trial court must set forth the findings of fact and conclusions of law. But the fact that it framed it so that the trial court has to set out its reasoning for either granting or denying indicates that they did anticipate that the state would be able to seek review of a granting of an expungement order in this court. And in this case, the court abused its discretion in 4 ways. 1, accepting a facially deficient petition. 2, ignoring evidence of ineligibility in its own record. 3, ignoring the state's evidence presented in its response. And 4, as I indicated, failing to set forth findings of fact and conclusions of law in its order as required in the statute, which would be able for us to come before this court to know what legal arguments she accepted or rejected and what evidence the trial court accepted or rejected.
Well, that raises an interesting question, and maybe you can help us. Was there any evidence presented in the proceedings below relating to expungement?
Yes, the state did present 3 things in its response, 2 of which were already in the court record, and of course that's the information and the pre-sentence report. And the third thing that the state presented was the police reports in their entirety. And providing
okay, well, let's stop there. Are the police reports attached to your response? Is that evidence?
It is something that the court can consider with regard to determining a factual basis. We did provide a case in supplemental briefing with regard to that. However, what it does do is, at minimum, set forward a case indicating that there is evidence of ineligibility. Now, the defense does indicate that the state should not, the trial court did not err in denying or not holding a hearing because the state did not explicitly request an evidentiary hearing. And that brings me back to the facially deficient petition, because there's nothing in that petition that indicates that the defense was going to, that the defense made some sort of prima facie case that there was the counts 1 and 4 in particular met the weight limit threshold in section A1 of the statute. So at that point, when the state presents the police report showing that it's well over the threshold for both of those cases, there's no indication to the state whether the defense would...
I'm going to take you back. You just said when the state presents evidence. I want to focus. A police report, how is that evidence? Because from my perspective, it's inadmissible hearsay. How do you get around the fact that a police report, not even a certified copy, is evidence?
Well, it does present a disputed fact. It puts on notice.
It suggests maybe
It does
a disputed fact.
It does suggest, and again...
But again, my question, evidence? Would you allow the defendant to rely on an uncertified police report and say that's evidence? Would you concede that here today?
I would not, I would direct
And
the
would you
court.
concede then that you didn't have evidence either?
It,
And I'm talking about admissible evidence to establish, to prove a point, not necessarily suggest an issue. I don't want to make you think I'm trying to trap you there, but that was not evidence.
correct, but it does suggest that there is an eligibility from which then, if the defendant disputes that, then the court needs to hold a hearing.
And so, and I don't want to steal someone else's words, but I'm going to, that maybe suggests a colorable claim on the state's part.
Correct.
So again, with all of the other things you mentioned, or the other things you mentioned, the information again isn't really evidence. It's just a document that suggests there's a colorable claim.
Correct. And going back to what
So
you said.
then, why didn't the state ask for a hearing?
Because, thank you, because at that point, there was no indication that this was going to be an issue. You mentioned earlier about what if the defendant had put something in the petition. And in fact, if we look at the form that was created by our Supreme Court for these specific issues, they do actually provide a means by which the petitioner can, in its discretion, it's optional, can provide supporting documentation. And Rule 36 specifically in A2 and B2 does specifically anticipate that a petitioner would do that. And in cases where, in particular, like count 4, the cannabis count, there's nothing in the court record, and there was no guilty plea, you would need to do that.
When a defendant comes forward and makes the claim, then the state has a burden, right, of meeting the evidence by clear and convincing evidence.
Correct, but there needs...
So if the state didn't provide actual evidence, I'm struggling with why it's not waived. And because at no point below did you say, oh, well, give us a hearing. Maybe down the road you do and we'll face this issue at a different time, but how did not you, but the state not waive its claim for a hearing below because it never asked for one?
Because at that point, because the petitioner did not provide a clear prima facie case, a burden of going forward, then the state had no... Okay.
But you knew that the court was going to have to decide that issue.
But it was not clear...
Did the state not just take a chance and end up waiving a claim in the process?
The state had no... At that point, the state did not know whether that was going to be a material issue of fact. The only thing that was in the petition was an argument that... There's an argument that the perpetuatory offense made him eligible.
I'm going to tease that out. Once the defendant filed a petition saying I qualify, how could the state not know that that was at issue? Because this defendant had to allege that it was less than 2.5 ounces. It absolutely was at issue at that very moment.
But if you look at the petition, though, in its entirety, it only talks about count 1, and it never talks about count 4. And yet we end up with the expungement of count 4 as well.
To one count, and that count doesn't include an amount. So how is the state, I don't even understand how that other count matters at this point.
Well, because the state's argument, Your Honor, is that the petitioner has the burden of coming forward with the basic elements under A1, which the petitioner did not do. So, for instance, if you, and it's a very...
Did the count he pled to, and that's the only count that's before us, did the count he pled to require any specific amount?
No.
And no specific amount was established at the plea?
Correct.
So the count he's asking to have expunged doesn't include a specific amount?
Correct.
So how is the state arguing that, because there was another one that we voluntarily dismissed that would have included more, that somehow insulates you from a waiver? I'm still struggling with why you didn't waive.
Well, let me help you out.
All right.
So he files a petition, and doesn't he have to make an affirmative assertion in the petition that he qualifies under the statute at that point in time?
Yes, and he didn't do that in this case.
And so he makes an affirmative assertion, and you respond by saying, not true, not true. here's a police report that shows that you actually had whatever it was, but way above the statutory threshold.
Correct.
So at that point in time, isn't there a material dispute that would require the court to hold a hearing to resolve the material dispute?
Yes. If we assume that just the filing of the petition itself is an affirmative declaration that it's under the threshold, but in this particular petition didn't even do that, and it really doesn't take much to do that.
Well, does it really require more than that? I mean, if the statute says you qualify if it's under 2.5 ounces, and you say, I qualify, isn't that an affirmative assertion that it was under 2.5 ounces?
Not necessarily, because the state does have to make findings of fact and conclusions of law, and simply filing a petition that avoids the question doesn't do that.
Well, if he says, I had less than 2.5 ounces, and you had filed no response, couldn't the court at then a point in time rely on that assertion alone to grant the petition?
In that case, though, the petitioner is saying, I had less than 2.5 ounces.
Okay, so if he checks the box that says, I qualify,
Right.
then and the state does not respond, we're at the same point, aren't we?
Yes.
So it's only when you've raised the issue of, that may not be true. There's a material dispute here.
Correct. But in this case, they didn't present the petition where he would have to have, where the petitioner would have checked the box that specifically outlines the 2.5 ounces and signed it saying that I declare to the best of my knowledge that this is true and correct.
It was not a certified petition?
No.
Okay. And I want to, your time is running out, so I want to ask you some really basic questions. Do you believe the rules of evidence apply at a hearing in this context?
I mean, that's not clear from the statute, but at a hearing?
Yes.
Well, if it's, I suppose it depends upon the type of hearing that the court grants. It's not really clear whether the court
Well, in this case,
necessarily
we have a
needs to.
dispute on the weight of the marijuana.
Right. And the court can grant, oral argument, or it can grant an evidentiary hearing.
Okay,
Now,
and
with
so
regard to an oral argument.
in this case, we have Judge Tuho, who is going to have to make that conclusion. So do the rules of evidence at a hearing apply?
Yes. If it's an evidentiary hearing.
It's your burden at that point in time at a hearing to prove by clear and convincing evidence, right?
Correct.
So isn't a clear and convincing evidence standard based upon the rules of evidence?
Yes. I would say, though, that when the court has evidence in its own court file, as it did in this case, and can take judicial notice, they may not hold an evidentiary hearing, but simply oral argument where the parties can argue the admissibility of whether the court should take judicial notice of its own records.
Okay.
Counsel, would you consider an expungement proceeding to be a civil or criminal proceeding?
Well, I think the statute anticipates that it's a criminal proceeding, particularly with regard, if you look at Section 5, where it specifically cites 13-4033 as a criminal appeal. That's, yeah.
Thanks.
Counsel, just, it seems that the parties have conceded the inchoate crimes, and not saying beyond this case, but have conceded inchoate crimes can be subject to expungement. And is that the case here? And again, not taking it beyond this case, but in this case, that's been conceded.
Yes, because we think that the court needs to take account of the underlying offense. And in particular, you have to, because of the very low threshold for expungement in this case, or in any case.
one other follow-up to Judge Payton, which is, if this is in fact a criminal case, how does the state have a right to go beyond the four corners of the plea agreement to try and prove weight? Because normally we would hold the parties to the evidence they presented or could have presented. The state could have taken it to trial and proved it was 10 pounds, but didn't. So it seems there was a full and fair opportunity to litigate that issue. The state decided not to enter the plea for an indeterminate amount. So how does that not tie the state to the four corners of the plea agreement, and the state doesn't get to come in and offer more evidence?
Because in multiple cases, this court has stated that it can look at anything besides the four corners of the plea or in its own record to make that determination.
But then with the record established below, are you just litigating the record from below? Well, it seems to me there's nothing there. That's the problem.
Yes, and the statute itself anticipates that there would be additional evidence that may be presented if necessary, which it would be in this case.
Counsel, your time has expired. Thank you very much for your presentation.
Good morning, may it please the court. My name is Derek Debus. I have the privilege of representing Mr. Santillanes, the appellee in this matter. The decision of the court below should stand for two main reasons.
Did Judge Ryan Tuhill make findings of facts and conclusions of law?
My apologies, Your Honor.
Judge Ryan Tuhill, did she make findings of fact and conclusions of law?
I don't have the trial court's order in front of me right now, Your Honor, but I believe she did, yes.
It doesn't seem to me she did. So if on that basis alone, shouldn't this case be remanded?
Remanded solely for the trial court to...
If we remand it, she can do whatever she wants with it.
Yes, Your Honor.
Okay. In this situation, do you believe the state has just conceded that the rules of evidence apply? If there's a hearing, do the rules of evidence apply?
Absolutely, Your Honor.
And to Judge Goss's point, was there ever a requirement in this plea agreement to determine the weight of the contraband?
No, Your Honor. The plea was to...
There was nothing. The weight of the contraband was simply irrelevant to the charge being pled to.
Yes, Your Honor.
So there was no reason for either side at the change of plea to make any determination about the particular weight of the contraband.
Well, Your Honor, I believe just as a matter of best practice, the state should be making...
That's not what I asked, is it? I said, was there any reason why any side would make a determination of the weight at the change of plea?
No, Your Honor.
It was irrelevant.
Yes, Your Honor.
All right. In this case...
Can I do a follow-up before you move on?
Sure.
Just a very quick follow-up. But as a matter of res judicata, did the state have a full and fair opportunity to litigate the weight in this case?
Numerous opportunities, Your Honor, absolutely.
And if they
Full and fair opportunity to litigate an irrelevant issue?
Well, Your Honor, they could have litigated the amount of marijuana by proceeding with the charge that was initially filed rather than offering a plea deal. And they could have litigated the amount of marijuana in this case by simply requesting an evidentiary hearing, but they decided not to.
An evidentiary hearing when? At the change of plea or?
An evidentiary hearing in regards to the petition. They could have requested an evidentiary hearing and presented a shred of evidence regarding the petitioner's ineligibility. The state chose not to, and the court did not abuse its discretion in concluding that an unverified police report submitted without foundation did not meet the state's burden of clear and convincing evidence.
Could you ever have clear and convincing evidence in a response to an expungement petition?
Your Honor, if the rules of evidence apply, which I believe they do and the state believes it does as well, then I don't believe that simply attaching foundationless and unverified documents created by the state's agents would ever meet the burden of clear and convincing evidence.
Oh, I agree with that, but doesn't that create a colorable claim regarding whether or not the facts were, your factual assertion that your client possessed less than 2.5 ounces?
Especially where, as here, the plea agreement and factual basis are silent as to the amount at issue.
Absolutely, Your Honors. So as an initial matter, it's not to the petitioner to prove that the amount of marijuana they may or may not have had. The burden clearly rests with the state to prove ineligibility for expungement beyond or by clear and convincing evidence.
Well, hold on. I agree that once you've made the assertion, but your client would have to make a factual assertion that he or she qualifies for expungement under the statute, right?
Yes, Your Honor, and the charge to which he pled, the facilitation charge, is an expungement-eligible offense.
That's not a dispute, but it is a expungement eligible crime, but in order to qualify under the statute, you would have to make an affirmative assertion that in committing this crime, you possessed less than 2.5 ounces, not you, but your client, possessed less than 2.5 ounces of the contraband, correct?
Yes, Your Honor.
Well, if that's the case, you make that factual assertion. The state presents evidence that, no, that's not true. You possessed more than that. Don't you have a material dispute at that point in time that needs to be resolved by the trial court?
Your Honor, the state did not present evidence. They attached an unverified, foundationless police report.
Absolutely. It has to be a material dispute that requires a finding of fact and conclusion of law after an evidentiary hearing.
Yes, Your Honor. And in this case, the trial court did not abuse its discretion by concluding that there was not a genuine dispute of material fact because the state decided not to request an evidentiary hearing.
So,
the trial court...
Before you move on, I want to tease out something from Judge McBride. The attachment of the documents, unverified and such, and I understand the not evidence, and I don't think there's really an argument about that, but is that enough to establish a colorable claim for the state to get an evidentiary hearing?
I believe in conjunction with a request for an evidentiary hearing, it would indicate to the court that there was a genuine dispute of material facts.
Okay. And I'm sorry, were you going to follow up with something?
No, I'm done.
Then I guess my next question is, which I asked the state, can the state in a case like this go outside the four corners of the plea agreement to prove that? In other words, outside the evidence actually that was part of the underlying criminal case?
ARS 36-2862 contemplates that arrests, charges, indictments, convictions, and sentences can be expunged. The disjunctive use of the word "or" indicates that while an arrest or an indictment may not properly be expunged, the underlying conviction, if it is expungement eligible, would be expungible.
So in other words, they may be able to mix the bag and prove evidence for one thing but not the other.
My position is that the state could go outside the corners of the plea in order to prevent a arrest record or an indictment or an information from being expunged. However, for the charge itself, the state is bound by the factual basis in the plea with which it decided to resolve the case.
But the factual basis is silent as to eligibility for expungement.
Absolutely, Your Honor, and that is why it's the state's burden to then prove to the trial court by clear and convincing evidence that the petitioner is not ineligible.
But how can the state prove that if it's not allowed to go outside the plea agreement and present police reports, et cetera?
Well, Your Honor, if the state pleads a case down to an expungement-eligible offense, the state is bound by that. They can dispute whether the arrest, whether the police reports, whether the indictment or information should also be expunged, but they're bound by their decision to resolve the case with an expungement-eligible offense.
But hold on. It's an expungement-eligible offense. We've already established that. No one is disputing that. The state just conceded that point. But it's only a expungement element if the offense only related to the lesser amount of the contraband. And that was not in dispute when they entered into the plea. So there's nothing inconsistent with the state saying, yes, he committed facilitation, but he facilitated more than the threshold that's contained in the statute.
Your Honor, if the state wanted to die on that hill and maintain that Mr. Santillanes had more than the expungement amount, they could have provided a more thorough factual basis at the change of plea. They could have requested...
It's not relevant at that point in time, is it?
Your Honor, it would not be relevant at that point of time, but if the state was so intent on tagging Mr. Santillanes with the fact that he allegedly had...
So 10 years ago, when it was absolutely expungement was not on anybody's radar screen, the state was supposed to be so clairvoyant that they would stand up and say, Your Honor, I know it's not relevant to this, and I'm completely wasting your time, but I would like to go through all of the things that happened so that 10 years from now, when the people decide that they're going to create an expungement statute, that we would like to make sure that the record is clear. Is that what you're saying the law should be?
No, Your Honor. What I'm saying is that if the state was intent on tagging Mr. Santillanes with the fact that he had more than 2.5 ounces or 10 pounds or whatever amount that they allege he had at the time, they should have proceeded with those charges and proved the amounts at issue beyond a reasonable doubt in court. Instead, for whatever reason...
So they should have not even entered into this plea agreement. They should have nailed him. And that's so much better for your client, for him to be nailed with all of those greater charges, rather than giving the state the opportunity to present at a later date whether or not he or she had more than the threshold amount.
Respectfully, Your Honor, that is absolutely not what I'm saying. What I'm saying is that the state had the opportunity to prove the amount of marijuana at issue in this case numerous times, and at each opportunity, for whatever reason, whether insufficiency of the evidence, lack of strength in the case, or judicial efficiency, they decided not to, and instead decided to offer a plea to a charge that is now expungement eligible. If the state wanted to prove the amount of marijuana at issue, they could have proceeded with the original charges, or they simply could have requested an evidentiary hearing in this expungement petition. They chose not to. They phoned it in the court below. They lost. That's the result that should have happened. That's the result that happened, and that's the result that should stand.
So walk me through how the process in the evidentiary hearing. So at the evidentiary hearing, had there been one, the state could have presented the police report, the sentencing, or the arrest documents, et cetera, correct?
The state could have subpoenaed the arresting officer, the officer that was involved in the search, the criminalist who ended up testing the marijuana. They could have presented any amount of evidence necessary to meet their burden. But simply put, a police report is not enough. In DCS cases where the burden is clear and convincing to remove a child from a parent's custody, a DCS report is not enough. There has to be a hearing before an ALJ, and there has to be a finding and determination with actual evidence presented.
Okay, but you concede that based on the language of the statute, the state could present this evidence, this outside, police report, et cetera. They would just need to have somebody testify to it at the evidentiary hearing, correct?
Well, the police report wouldn't be admitted into evidence, Your Honor, but the testimony of the arresting officer would be.
Okay.
But just so we're clear, and this is I'm taking this from Judge Payne's question, is that if we had had a hearing under this statute, the state could have called the criminalist to say, yes, she testified or he tested the contraband, and it was above the threshold.
Yes, Your Honor.
And that would have met their evidentiary burden.
That would be a question for the trial court judge as to whether she was persuaded by clear and convincing evidence by that criminalist's testimony, Your Honor.
But based on previous question, as to an arrest and information and indictment, do you agree with that would also apply to the conviction?
I'm not sure I understand the
In
question.
other words, you had previously said that as far as the conviction based on the plea, I thought you said they were bound by the four corners, that evidence would be relevant to things that may have been also able to be expunged, the arrest and things like that, and that the arrest probably couldn't be expunged under that.
Yes, Your Honor. The court could find that there was clear and convincing evidence of ineligibility for the arrest to be expunged, but not clear and convincing evidence for the underlying facilitation charge to be expunged.
Why? If they prove that what he was facilitating was more than 2.5 ounces, why could what allows the court to expunge his conviction?
Simply put, Your Honor, the charge itself does not contemplate 10 pounds of marijuana. Arizona law does not break our thresholds up into 2.5 ounces or more. So given that the plea agreement is silent as to what amount was actually facilitated, the fact that nothing was proven in court should not be held against the petitioner.
But that goes right back to what I asked you right in the beginning. Doesn't he have to affirmatively assert that he was facilitating less than 2.5 ounces in order to qualify for expungement?
Yes.
And if he asserts that, what prohibits the state from saying that's not true? You facilitated more than 2.5 ounces, so you don't qualify. So the conviction should not be expunged.
What would prevent the state from doing that? Nothing, Your Honor, but the state would still have the burden of proving by clear and convincing evidence the ineligibility.
At a hearing.
Absolutely, Your Honor.
So your answer to Judge Goss was not correct, because you were saying if we had had a hearing and the state had proven by clear and convincing evidence that the amount facilitated was greater than the threshold amount, the conviction would not be expunged. If the state met its burden and said, no, it was 5 pounds of marijuana, or whatever the amount would be, the conviction is not eligible for expungement at that point in time.
If the state proves by clear and convincing evidence that more than 2.5 ounces of marijuana were facilitated to be possessed, then correct, the charge would not be eligible for expungement, the conviction would not be eligible for expungement. But again, that did not happen in this case, Your Honor.
We didn't have a hearing.
The state did not request a hearing and then waived any complaints as to not having a hearing. They simply had to put evidentiary hearing requested on their responsive pleading. They chose not to. And the state's assertion that there was no indication that this would be an issue is unavailing. That is not an excuse that would work for any litigant before this court, and it's not one that should work for the state. The state has the burden to prove their case beyond clear and convincing evidence. They did not, and they chose not to in this case.
I just kind of want to circle back to one point, though. Didn't the judge have to make findings of fact?
Under the
Specific
statute,
findings
yes.
of fact? And if the judge didn't, we remand, and then isn't it kind of all open again for everybody to go at it in the way that they need to?
If this court was inclined to remand this case back to the trial court, my position is that it should be remanded solely for the judge to provide findings of fact and conclusions of law regarding the expungement eligibility of the Class 6 facilitation offense.
Isn't that something we usually do when we just simply stay the appeal for the judge to do that? We don't usually do that at this stage.
Your Honor, that actually brings up another point that I wanted to address. The fact that the expungement has happened. The cat's out of the bag. The bell can't be unrung. Mr. Santillanes, for the first time in over a decade, can say he is not a convicted felon. The state could have motioned to reconsider, for the trial court to reconsider its findings. The state could have moved to stay the grant of expungement pending appeal. The state chose not to. So the cat's out of the bag, Your Honor, and I think remand would be inappropriate at this time because of the prejudice and inequity that Mr. Santillanes would suffer.
But what about the error in the court's minute entry? When it listed the charges, it actually said that he was charged with 2 counts of possession or use of marijuana for sale, which involved 2 1/2 ounces or less of marijuana, when he was actually charged with 4 pounds or less as to count 1 and 2 pounds or less as to count 2. Wasn't that an error warranting remand?
It may be an error, Your Honor, but I don't necessarily agree that it would warrant remand. Minor clerical errors and technical errors in minute entries can be corrected in a variety of ways that don't necessarily involve setting aside the judgment and remanding for further proceedings.
Let me just ask, because your argument seems to set it up so it doesn't matter if a judge gets it completely wrong, the state's going to be stuck, because we're never going to get a special action resolved fast enough before the cat's out of the bag, as you put it. It seems to me that you would be arguing we have no power to do anything once the Superior Court issues an expungement order. How would that not be the case? If the state can't appeal, has to do it by special action, and the cat's already out of the bag.
Well, Your Honor, first the state could motion to stay the grant of expungement pending an appeal.
And that's
Secondly,
denied. Then what happens?
at that point, I believe that decision to deny could be reviewable under either special action or as a direct appeal to this court under an abuse of discretion
But the
standard.
cat's already out of the bag at that point.
That's the intent of the voters, Your Honor. The voters intended marijuana expungements to be easily obtained and difficult to combat.
If they meet the statutory threshold.
If the state proves by clear and convincing evidence that they do not meet the statutory threshold.
If your client asserts that it meets the statutory threshold, they don't just automatically expunge everybody.
Correct.
You have to assert it. And you have to assert that you qualify, not you, but your client, has to assert that you qualify under the statute. And then at that point in time, the statute specifically gives the state the opportunity to rebut that by clear and convincing evidence that that is not correct. So it's not that they easily want these done. There's a process involved. And that process wasn't met here, was it?
The process in terms of the state meeting its burden by clear and convincing evidence absolutely was not met in this case, Your Honor.
So, and I'm just following up almost in a waiver argument. What you said is the state could have asked to stay the expungement below.
Absolutely.
And it could have been denied, but then the state also could have asked us to stay that pending resolution of special action.
Absolutely, Your Honor.
But actually they appealed. What do we do with that? Normally an appeal would stay it until we issued a final decision. If we find that they don't have a right to an appeal and also didn't ask for a stay, do they lose?
Yes, Your Honor. The state does not have a right to appeal in this case. There are no substantial rights of the state at play at issue in this case at all. The state rotely asserts that they have a substantial right to maintain their criminal convictions, but there is not a shred of authority that supports that proposition.
But wouldn't that holding lead to an absurd result? What if the Superior Court mistakenly expunged, an ag assault conviction or something like that? Are you saying the state has no opportunity to challenge that on appeal, even via special action?
No, Your Honor. If the court clearly expunges an offense that clearly is expungement ineligible, then that would be an abuse of discretion and the conclusions of law would be reviewed by this court de novo. And I don't think that result conflicts with what we're arguing in this case, because we're talking about a marijuana expungement. And if the court mistakenly expunges a murder conviction or an aggravated assault conviction, that is a clear error and an abuse of discretion that this court should review, and the state would have an opportunity to review as clearly erroneous.
Anything else?
Thank you, Your Honors.
All right, thank you. The case is deemed submitted. We'll issue a decision in due course.